So now we're past the openings.
Openings are done. Boom. So
What's the next day that's gonna happen?
The prosecutors, since they have the burden, meaning it's their job, it's their main job to prove the case. They have to bring witnesses.
Okay.
All right. And the way they bring witnesses, you bring the arresting officer, the victim, the person who this happened to. If there's DNA case, the person who took the DNA swab. They bring just like their case, different witnesses. And they start asking questions, which I call, it's direct examinations, what I call open-ended questions.
Okay.
What happened, where, I used to say why, what, where, how, who.
Okay.
Open-ended questions.
So they have to do open-ended questions.
Why do they have to do it?
Because they can't tell you what to say.
They cannot lead the
They
witness.
cannot ask yes or no questions. It's either
But
yes or no
that's-
questions or open-ended
Why?
questions. Right.
Because else they would be testifying
Yes.
themselves.
Exactly.
So
Exactly.
the reason why you're a witness is because you're testifying about what you know. If they're telling you what to say, they weren't there.
Yeah, exactly.
So why are you telling me, the juror, about an offense that allegedly occurred when you weren't there? So I want to take the witness's word for it, not your word, what you took from the witness.
Right.
The witness could have manipulated you, and now you believe the witness. So
Yeah.
now you're trying Eugene based on, because you feel some type of way, the way the witness told you about it, and you believe the witness.
Like basically, do not dress it up better than what it is. I want to hear it from the witness
Exactly.
firsthand.
Example would be this, right? A prosecutor cannot ask, didn't you see the defendant point a gun at Mary?
Yeah.
Yeah.
Right? You can't say that because that's leading. The answer is in the question.
He's
But the
telling him,
prosecutor
yeah.
can say, did you see the defendant there?
Yes, I did.
What happened?
What did you
What
see?
did
the
you
defendant
see him do, if anything? Right?
I saw him
pull out-
picking his nose.
And my favorite. My favorite.
But it's
What if
I saw-
anything
I saw
did
him pull out
he
his water
do
bottle.
when he grabbed the gun?
Yeah, I know, you can't say that.
What if anything did he do? No, if he says, yeah, he grabbed the gun. What if anything did he do? What if anything?
What if anything? Did he
opened?
do anything? But my point
What
is,
if anything is
because
there?
this is what happens during the trial, and sometimes the prosecutor is taken by surprise because they say, "What did you see?" I saw him grab a knife. Prosecutor's like, "What are you talking about?
It's a good case.
Yeah, what are you talking about?"
So it's a preparation. It's how you prepare your witness. But that is what direct examination is, really.
Yeah. I think there's a deeper legal truth that we're kind of talking about, which is this idea that the jury wants to judge the credibility of the testimony, and that can only be done accurately if the testimony is coming clearly from the witness as compared to being fed to the witness. by the
Exactly.
prosecutor.
That's
Exactly.
specific.